The European Court of Human Rights has dealt with a complaint of a gay activist. He had ordered a cake from a bakery and had asked the bakery to write the slogan "Support Gay Marriage" on the cake. The bakery refused. The owner said the slogan was against his Christian beliefs. That's the case I'm going to talk about in today's video. In Lee v. United Kingdom, the European Court of Human Rights examined an application of a man who had ordered a cake from a bakery. He had asked the bakery to write the slogan "Support Gay Marriage" on the cake. The bakery refused to fulfill the order. The man submitted a civil action in which he alleged that he had been discriminated against. He lost the case in the United Kingdom and went to the European Court of Human Rights. The European Court of Human Rights held that his application was inadmissible. A few words on the background. In England, Wales and Scotland, laws were introduced in 2014 that allowed for same-sex marriage. This led to a debate in Northern Ireland whether similar laws should be introduced there. This was voted on 5 times in Northern Ireland between 2012 and 2015. Each time, the result was that same-sex marriages would not be allowed. The applicant in the case was a homosexual man who worked with Queer Space. Queer Space is an organization that campaigns for the rights of lesbians, gay, bisexual and transgender people in Northern Ireland. After the Parliament in Northern Ireland voted against the introduction of same-sex marriage for the 3rd time, the complainant wanted to attend an event. The event was to mark the end of Anti-Homophobia Week in Northern Ireland. The applicant planned to bring a cake to the event. This cake was supposed to feature the logo of Queer Space, the organization the applicant was involved with, and the slogan "Support Gay Marriage." He contacted the bakery that advertised that it offered cakes with pictures, words, slogans and so on. The applicant then placed the order and paid. A few days later, the bakery called him and said that they unfortunately could not fulfill his order. They said the bakery was a Christian enterprise and that the slogan was against their Christian beliefs. The owners of the bakery apologized and paid the money back. The applicant then complained to the Equality Commission for Northern Ireland. With the support of that commission, he filed a complaint against the bakery. He claimed that he had been discriminated against because of his sexual orientation. He invoked various pieces of legislation from Northern Ireland and the United Kingdom which state that direct or indirect discrimination on the basis of sexual orientation, political opinion or religious belief is unlawful. Proceedings took place in court. The applicant claimed that the owners of the bakery had taken offense because he was homosexual. However, he said he had not asked them to support his political cause, but to bake a cake. The owners of the bakery said that they had not refused to carry out the order because the applicant was homosexual. They had not even known whether the applicant was gay. They had believed that making the cake would have promoted the political campaign for same-sex marriage in Northern Ireland. However, in their view, same-sex marriage was a sin and contrary to their Christian beliefs. The Court of First Instance pronounced a judgment in favor of the complainant. The Second Instance Court upheld this judgment. Then the case went to the Supreme Court. The Supreme Court said that there was no discrimination on the basis of sexual orientation. The owners of the bakery had been able to prove in the proceedings that they had both employed homosexual persons in their bakery and sold goods to homosexual persons in the past. So the Supreme Court said that the issue was not the person of the applicant, but the message which he had wanted to spread. The bakery was not discriminating against homosexuals as persons. It simply did not want to spread the message that same-sex marriage was desirable. The applicant then filed an application with the European Court of Human Rights. He claimed that the Supreme Court's decision had violated several of his rights under the ECtHR. On the one hand, his right to private life under Article 8 ECtHR. The European Court of Human Rights has often confirmed that the right to private life under Article 8 ECtHR includes sexual orientation. In addition, the applicant relied on Article 9, which guarantees freedom of religion and conscience, Article 10, that is freedom of opinion and expression, and Article 14 ECtHR, which prohibits discrimination. Each of these articles raises interesting legal issues. However, the European Court of Human Rights did not examine them in substance at all. It declared the application inadmissible. According to the European Court of Human Rights, the applicant had failed to exhaust domestic legal remedies. Before lodging an application with the European Court of Human Rights, applicants must exhaust all domestic legal remedies. That means, roughly speaking, that they must do everything they can to defend themselves against the violation of their rights under the European Convention on Human Rights, in the state against which they later on submit an application. This requirement of exhausting domestic legal remedies has two aspects. One is that you have to go through the whole process of appeal. In other words, you must go all the way to the highest judicial authority that one can appeal to according to the laws of the respective state. But the requirement to exhaust domestic legal remedies has also a second aspect, and this is often overlooked. You have to advance the arguments on which you rely before the European Court of Human Rights, at least in substance, at the national level. The European Court of Human Rights does not examine a case again in its entirety from a legal point of view. It only deals with the question whether the European Convention on Human Rights has been violated. In other words, in the proceedings before the European Court of Human Rights, one must assert, I am invoking this and that article of the ECtHR, and my rights under this article have been violated in such and such way. Exhaustion of domestic remedy now means that you basically have to do the same at the national level. You have to make it clear that you feel that your rights under the ECtHR have been violated, and why. This gives the national court the possibility to examine that question. It is not necessary to expressly refer to an article of the ECtHR. However, it must be clear that one refers to it in terms of content. For example, when it comes to freedom of expression, you do not have to mention the words Article 10, but you must make it clear to the domestic court that you feel limited in your ability to state your opinion or say what you want. And in that case, the European Court of Human Rights said, the applicant in the case has only invoked discrimination before national courts. It was only about the laws in the United Kingdom that prohibit discrimination. But he never expressly mentioned the European Convention on Human Rights or the rights enshrined therein. The court also pointed out that in the United Kingdom there's the Human Rights Act. That is a law that expressly incorporates the rights and freedoms enshrined in the ECtHR into UK law. The court then said, if there's such a law, then that speaks all the more in favor of invoking the corresponding rights. However, the complainant had not done so, although he had received legal advice from the very beginning. Based on these considerations, the European Court of Human Rights came to the conclusion that the complainant had not exhausted domestic remedies, and therefore declared the application inadmissible. What can we learn from this? In my view, is that it's worthwhile to examine at the national level whether a case has fundamental rights aspects. And in this case, that was actually obvious. If that is the case, then one should already refer to the European Convention on Human Rights in the domestic court. This does not necessarily have to be the focus of one's own argument, but it's at least on the record that you've done so, and the application won't be rejected for failure to exhaust domestic legal remedies.